For sure. I had that set up. Well, hello there, everybody, and welcome. Thank you for being here today. We are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there is my telephone number, and of course, my email address. I like talking with people and helping them out on the things that they're working on, and so if I can help you in any way, sometimes telephone's the best thing, sometimes it's the email. So please don't give up. And if you do send me a message, by the way, and I don't respond right away, probably because I'm doing something like for example, today I do this webinar, and then I'm going to be at NAR's meeting. Question. Already I have a question. I can be on. Oh, okay, thank you, Luda. Anyway, and then at 12:30, I'm at NAR in Anaheim at the Risk Management Issues Committee meeting, and then back again this afternoon to do a class on what I don't remember. Anyway, I'm doing a class this afternoon as well. And that being said, thank you, and thank you everyone, and Luda. Thank you, Luda, for being here today. I always appreciate your time. I've got a little bit of credentials, I guess, that make me qualified to talk about the subject matter today, and I'm hoping you'll give me feedback. I think that's really important for all of us. But I do continue to teach continuing education for attorneys at UCSD, an MCLE approved program there. I've got a broker's license in several states, been in real estate for well over 40 years, since before most people were even born. And I know people that have been doing it longer than I have, who are just excellent to work with. I did teach property management at the college level for many years. As you can see on the right-hand side, risk management is really my game. That's kind of what I'm most concerned about. So we're going to be talking about stuff that's going to appear to be legal. I am not a practicing attorney. I do a lot of trial work. In fact, I just got off the phone with an attorney, limited testifying as an expert witness. And so again, that's a title, a court-certified expert witness. Remember, the Department of Real Estate says you may not call yourself an expert other than in a title. So if you're a CDPE, a certified distressed property expert, then you can call yourself a certified distressed property expert, but you can't just call yourself an expert. So that being said, standard of care is my specialty. Did the agent do what they were supposed to do in the real estate transaction? Agent's duties of inspection and disclosure, market conditions in San Diego County. And so conversation today, not intended to be a substitute for the advice of your broker. And by the way, we have quite a few brokers on the call today. And so, as I always say, you should be talking to yourself. And if you're not, then talk to me. I'm happy to help, whatever I can do. Nor for that of your attorney, please consult with them as appropriate. Okay. So if your attorney tells you to do something, you really need to follow their advice. If your broker tells you to do something, you need to follow their advice. All right, that being said, our webinars are intended to be interactive. Please utilize the Q&A button to ask questions or offer input. Some of you have already figured out how to do that. And by the way, your questions are anonymous, so it won't actually show up on the screen. So when you type in your question, it will show up for me. I'll be able to see it. I'll probably reread it or paraphrase it. And then I might mention you by first name, but nobody's ever stupid in my class. Please ask questions. I would be insulting for me to think anything less. So I do look forward to hearing from you because it helps shape the direction that we're heading in. And so this morning we're going to talk about property management forms. This afternoon, I'm going to talk about how to create a template. There we go. Now I know what I'm talking about this afternoon, how to create a template. Probably my most favorite thing to do. You're going to be shocked at the things I'm going to show you. Some of you, like Luda, you get that kind of one-on-one and being the special person that you are. So I do like, hi, Carla, welcome back. And I do like helping people. Zip Forms can be a really good program when it works properly. And again, I've only been teaching it since it was WinForms back in the 90s. And it's gone through a lot of changes. And so, but I'm going to show you some neat little tricks of the trade that I think will make your job a lot easier. Okay. So that being said, Thursday morning, we're going to talk about the top 10 risk avoidance techniques. We used to call that lawsuit avoidance. And we changed the name only because it sounded like it was some kind of guarantee that you could stay out of a lawsuit. I'm in lawsuits all the time. It's just that they're always somebody else's. So, it just is what it is. I don't think you should be afraid of those things, but of course, if you're doing things the right way the first time, you shouldn't have anything to be worried about. And then in the afternoon, back by popular demand, we're going to talk about the changes to the RPA. And so some of you may know that there was a trial, a court decision recently called the Burnett decision that came out of Michigan, I believe. And that case, unfortunately, did not go well for us, for NAR. And so as a collective, us in California, we're not going to be quite impacted as much. But and in 13 states where where buyer representation agreements are mandated legislatively, they're not affected by it at all. But here we're going to talk about some changes to the contract. So C.A.R. took all of the forms that they had been ready to, the red line versions that they had been ready to go and release on towards the end of December. They took them off because they don't like to piecemeal fix things. So they're going to do some work on the buyer representation agreement and a few other things. And then they'll put them all back on there again. So I actually have the red line version from when prior to them taking them all off the website. So probably going to give you a little sneak peek into what that's going to look like on Thursday as well. Okay, so that being said, member benefits, thank you for joining us. Our discussion today, residential property management forms. We're going to talk about the forms. And so some key concepts I want to get out of the way really quick before we get into that. So it's residential, not commercial, and they are property management forms. Please check with your broker. Make sure your broker allows you to do property management. And some of you I know here today are brokers and are doing property management under your own broker's license. And so before you even attempt it, because you have to have your broker's permission, okay? So because not all brokers have insurance to cover property management, not all brokers perform property management, and you need to know by looking at your ICA agreement, your independent contractor agreement, whether you're even allowed to do that by virtue of being associated with the broker that you're with. Okay, so some other key concepts: are you a listing agent or are you a property manager? So what's the difference? The leasing agent, I'm sorry, I said listing. Leasing agent, once the keys or possession are handed over to the tenant lessee, then it's over. And you have to know that's the law in California. Once you hand over the keys, you've delivered possession. And likewise, when the lease is over with, the tenant has not surrendered possession of the property until they release all the keys that they were given at the time of the inception of the lease. And so we'll talk a little bit about that and some actual changes that we made in the form that will facilitate the understanding of, when does your agency relationship begin and end, and things like that. So a leasing agent, so this is somebody who's not doing property management. So a leasing agent does not answer calls about repairs, does not do repairs, does not accept rent checks, does not provide forms. And this is a common mistake that I see in the real estate industry, and that is, an owner wants to evict a tenant, and you're not property management, you do leases. So you provide the owner with the 3-day pay or quit form. And again, that's going to be considered property management. It's going to be considered casual property management. So we're talking a minute about that. So you want to make sure you don't cross that boundary. If you are property management, then you have certain things that you can do and by the way, I encourage property management. I mean, it's a different way of making money in real estate. It does not require a second license or a secondary license. Luda says, except for forms for leasing, the disclosure. I don't know what that means. Can you clarify that a little bit? That would help, Luda. Thank you. So they don't provide forms. So a leasing agent, anything that they interact with the owner of the property or the tenant of the property after the keys are delivered, anything prior to the next listing, those are all going to be considered property management. So again, casual property management, very dangerous, because the Department of Real Estate says you're doing property management. You can say you're not, but you are. Got it after. Okay, I think that means you understood it. Okay, so again, difference between a property manager and a leasing agent. All right, and I want to make sure we're clear today we're talking about property management. Okay. All right. So leasing agent versus casual property management. Again, a casual property manager is someone who says, I don't do property management, I'm a leasing agent, but then they do activities that would constitute property management. And the Department of Real Estate's pretty good about coming in and saying, you know what, we're going to say you're a property manager. You know, we're going to say you engaged in casual property management, even though you claim not to be a property manager. So again, as long as we can make those distinctions, we're in pretty good shape. Okay. All right. So as a general rule, doing real estate related activities on behalf of another in California requires a current California real estate license, and you must be operating under the supervision of a broker, unless of course you are the broker. And so as most all of you know, I encourage everybody to get their broker's license. I think you should have one. I think the truth will set you free. I think it's a good thing. I've never seen more zeros in a judgment just because you had a broker's license. I get the millions of excuses for why people don't do it. But again, to this day, I don't understand why not. Okay, so that being said, property management is the most investigated real estate entity by the California Department of Real Estate. And so if you get into property management, count on the fact that you're probably going to get a visit from time to time by the Department of Real Estate. That's not a bad thing necessarily. They stop by and they've changed their way of introducing themselves. They stop by now for educational opportunities. And so take advantage of that. You're talking to the source. Okay, so take advantage of that. You know, welcome the opportunity to work with the Department of Real Estate to make sure that you are doing things right. And our business is a systems business. And if you have a system set up, which you really should have in property management, if you've got a system set up, then they will look at your system. You know, just because things don't always go according to plan, but as long as you have a system, they're going to look at that as okay. Well, at least you've got something set up for how you're going to do your business. So kind of an important thing. So they have lots of handouts, landlordtenant.dre.ca.gov. They publish a California Tenants Guidebook. There's a reference book. It's the REF 09, and that's also on their website. Know Your Housing Rights. So they publish a lot of things for the tenant side of things, but they don't publish a lot of things for the landlord side of things, right? So because it's usually the tenant that's complaining. Interestingly enough, I did a podcast for the Department of Real Estate. Was it last Friday? They made a comment to me. They said that the highest number of complaints that they receive at the Department of Real Estate are from first-time home buyers. And I thought that was an interesting concept. I said, I think that's a shame, because that means that we're not taking the time to explain to people what's going on and what should happen in a real estate transaction. And if you don't know, you need to learn. And here you are today learning. And if you do know, you need to take the time to help people. That remember, when you're working with first-time home buyers, you're probably working with entry-level housing. And so it's very important to our economy in San Diego that we support the entry-level housing, because that makes the basis for our move-up housing. You know, when we're purchasing properties for more money, things like that. So it's really, really important. Okay, so why property management? Well, usually trust funds, and so this is why it is the single most investigated entity by the Department of Real Estate, and that is because money shows up missing. We already know we've got $6 million missing from trust funds right now in the state of California, and the DRE is looking for that money, and so it's just not uncommon for that to happen. Any questions so far? It's my excuse to get a drink of my berries tea from Ireland. Okay. C.A.R. has omitted, and some of you today I've talked with about this, omitted the trust funds forms. So they do have the trust fund forms online. And in fact, let me, and the reason was because a lot of the people were not doing trust funds or not doing property management. So let me take you to the DRE website. I'm in there every day. Let's take a look at forms up here in the upper right-hand corner. And these forms are going to happen to be in the 4500 series. So down here at the bottom, and here are the forms that used to be on the C.A.R. zip forms program, but then they said, hey, you know what? We're just putting, we're taking DRE's forms and plopping them right onto our logo, and so they said, oh, we think we're going to stop doing that. So these are the forms that you're going to use when you're doing property management. All right, so let's go head on back. That actually worked really well. I was surprised. Normally it doesn't work so well. So okay, so anyway, we omitted it from the zip forms library. So C.A.R. now refers interested brokers to the Department of Real Estate website for the use of their forms. And now we're going to concentrate our discussion on the following. And so we're going to talk about forms. We're going to talk about laws. We're going to talk about environmental hazards and how important that these things are. And so we're also going to talk about notices to the tenant. So C.A.R. forms to be included in all leasing situations, and that's going to be our disclosure regarding real estate agency relationship. And if you remember the form, it says up at the very top, this lease exceeds a year, and the law in California requires that you disclose the concept of agency on all leases that exceed a year. I mean, that's just the way that the law works. I personally think you should be disclosing the concept of agency in all leases. I don't care that it's over a year. If it's 2 months, I'm going to disclose agency only because I want to be very clear that everybody understands who I'm the agent for. Okay. All right. Secondly, especially for greater than a year, residential environmental hazards booklets, and again, when you're doing a sales transaction, we normally get that residential environmental hazards booklet usually through Property ID or one of the various natural hazard disclosure companies. Not all of them provide it, so be really careful about that because it's a statutory requirement. Where that means that the law requires that you provide the residential environmental hazards booklet to not only sales but also leases. And so in the leasing field or in the property management field, we don't usually do natural hazard disclosures. And so as a result, you need to go into the library, you need to get the residential environmental hazards booklets. And I'm going to show you in a minute how to do that. Okay. All right. Water heater statement of compliance. So we need to have that. That's included in a sales transaction. That's included on the bottom of page 2 of your transfer disclosure statement, as is the smoke detector statement of compliance. And so in a sales transaction, if you are using the current transfer disclosure statement, then you know that those have been provided for the client. Okay, good. All right. But again, in a lease transaction, we need to have a separate form. Water conserving plumbing fixtures and carbon monoxide detector notice. So make sure you have that in your file. And some of you, I think we need to probably review your file, make sure you have that. And then the burn form. It says notice regarding background investigation report pursuant to California law. So, when we're investigating people, which the law says when you're running a credit report, you're investigating people. When you're calling the past landlords, you're investigating people. So we're going to want to give the person notice of where we're getting that information from. Okay. All right. Tenant flood hazard disclosure. So that's the law. And we do have a form for that at the state of California. I'm going to tell you, as some of you know, because I've talked about it before, but the form itself, the default language says that it is not in the flood hazard zone. I think that's a mistake. I'm going to talk to C.A.R. about that, about rotating that language so that it will say that it is in the zone. The default language will say it is in the zone, but because essentially they don't sue you because you said it was in the zone and it turns out it's not in the zone, right? When they sue you, it's because you said it wasn't in the zone and in fact it is in the zone. So I'm going to, our template has that box checked that says it's in the zone, because I know that if it turns out it's not in the zone, then I know I'm okay. But I told you it was in the zone. So if it's in the zone, then, I've just prevented that potential lawsuit. Okay, so that being said, and then I have my rent cap and just cause addendum, which is a form that you need to make sure that you have in all of your transactions, that by now your leases, well, I shouldn't say that. I've got leases that have been running 5 and 6 years already, but I know on the ones that I do, that I know that those forms were provided. So make sure that that's included. And we're going to see that a lot of these forms are part of the template that is driven with C.A.R. So I'm going to show you that. So we have a lot to do. And yeah, I'm looking at my clock. Okay. Methamphetamine contamination notice, if applicable. So if there's been a spill, if there's been a notice filed about potential methamphetamine contamination in a property, you need to give that notice to the tenant. And the reason behind that is this, that the cleanup for those things is very specific. And if it's not done right, stuff can still go boom. So and I mean really big boom. so we need to make sure it's done right. But if there's an MCN, it's called, filed against the property, you need to let the tenant know about that right away. Lead-based paint and lead-based paint hazards disclosure. So that's our form for disclosing the potential for lead-based paint. I've never seen one filled out correctly. Paragraph number 1 talks about, other than the following, the seller of the property or the owner of the housing provider of the property is aware or not aware of potential lead-based paint. So those need to be checked NA through those fields. Okay, if assuming that they don't apply. If they do apply, then the owner needs to tell you that they do apply. Okay, so the penalty for this, by the way, it's fairly significant. It used to be that it was about $11,000 per offense. My understanding is it's much higher than that now. I think it's well over 14,000. But the damage that lead paint does to our children, to use them as the example, our children ingest it. It's sweet tasting. It causes permanent brain damage, and irreversible brain damage, obviously. And so it's a horrible thing to see. Even if you're going to go into, if you were going to disturb more than 6 square feet of lead paint area within a house, you have to have it done by a professional company. 20 square feet on the exterior of the house, you have to have that remediated by a professional company. Don't try to do this. This is not a self-help thing. Don't try to do this at home. Information on dampness and mold for renters in California, that is now attached to the lease agreement, and we're going to talk about that in a minute. Fair housing and discrimination advisory, of course. That's one of those forms that falls under the purview of what took us so long, and in my opinion, at least. Wire fraud, electronic funds transfer advisory, it's going on, it's getting worse. California Consumer Privacy Act advisory, that was updated recently, so make sure you're using the current forms on that. Bed bug disclosure, it's a statutory requirement in California. Periodic pest control, Megan's Law database disclosure, and again, I had this conversation with a property management company yesterday. You do not have an obligation at law to go to the database. In fact, I would recommend that you don't go to the database, but you must notify the prospective tenant of the existence of the database, and that we're going to see is actually in your form, so you don't necessarily need a separate disclosure for that. Okay, assuming of course you're going over the form with the client, which you should be doing. Military ordnance, so ordnance does not have an I in it. Ordnance means stuff that goes boom, and so there is no actual form for that. It's a statutory disclosure. You must make the disclosure. Service Members Relief Act, there's no form for that. And so it's funny because I had this conversation yesterday again. I had 2 Marine Corps helicopter pilots in my in a rental that I had on Portofino in Del Mar, and both sisters both lived with me for a year, not with me, but I mean lived in the property for years. They were Marine helicopter pilots, and so one day they got orders. Both of them got orders to to go out on tour, and so they called me up, and I said, "Thank you for your service. Have a great day, and you need to know that you may not by law hold a military person to an agreement when they get an order to go serve their country. So let's be careful about that." Obviously, if you have questions on any of this, you can always call me, or I can certainly send you to the resources to confirm all that. Death on the premises, that's California Civil Code 1710. That says that we must disclose the death on a property within 3 years. And that's all death on the property. You may disclose the cause of death if asked, but you don't have to disclose the cause of death when it is AIDS or HIV related. Question. Boy, Luda, you're good today. Keep it coming. Do you have to provide the military form if your tenant isn't active duty? And I'm not sure what form, because I don't think, pretty sure we don't have one. If your tenant isn't active duty, then they don't get orders. I mean, if they're in the reserves, okay, possibly they could get orders they could get called up, as we say. I was also in the reserves many years ago, and I think I'm beyond the age requirement to do that. So, but anyway, yeah, we don't have a form, but if they're on reserve and they get called up, I would say I wouldn't get in front of that. You can ask for proof, by the way. Will we get copies of the slides? If you want copies of the slides, send me an email, and I'm more than happy to send you. In fact, you're going to find in a minute I've got more than just slides for you, so I'm happy to send all that to you. And as most of you know, I load all of my videos up onto the YouTube website. I want you to have it. I think it should be part of a public domain. And so at this point, the webinars, I'm doing these on behalf of C.A.R. I'm loading them up onto my YouTube website because nobody else was loading them anywhere. So I figured I'd give you access to them really easily. But at some time in the future here, and not far from now, I'm going to be doing podcasts. And so that'll be a little bit different. They'll be shorter duration. There'll be question and answer podcasts. So for example, I'm going to be doing one we're going to start doing one on the buyer representation agreement. Obviously, everybody's going crazy about it right now. My BRBC, my buyer representation and broker compensation class, has been approved by the Department of Real Estate for 3 hours of continuing education credit. Now, that is going to be for the live in-person version, and so I'm trying to get in front of SDAR. But if that's not going to happen, I'm already getting started on doing those for NAREB and CARREB and some other associations that want me to do that for their organization. So I did the non-credit version for NAREB up in Oakland a couple of weeks ago. Great turnout. Everybody was so kind, and it worked out really, really well. So obviously, I do have some credentials on that. So question, you stated these forms a must in all leasing situations. Yeah, but we don't have a Service Members Relief Act form. I just want to clarify, do you provide them even if they don't pertain to the tenant? No, you don't have any reason to do so. I guess you would have to know whether or not the tenant was military. And so we don't always know, right? Sometimes, we have to ask. And I won't get into what I'm looking for to determine if somebody's military, but I can tell you when I walk around, I get saluted a lot. So the shorter my hair, the more likely I am going to be to get saluted. So thank you, Luda. Good question. Okay, all right. That being said, rental and management agreements. So we're going to talk about types of agreements. We're going to talk about the PMA here in a second. We're going to talk about the RPOD, and we're going to talk about the lease listing agreement. And then finally, we're going to talk about the residential lease or month-to-month rental agreement. So let's go ahead and get started. I want to take us over here to, I've already opened up the Zip Forms program to what we use when we do our property management. So, and by the way, I don't know if you have your picture set up where I'm on the side or on the top or whatever, but if you can always minimize me, you don't need to see my antics going on. So you're looking inside of our template for property management. And so again, when I go back to my list, these are all my templates. So again, remember what I was saying earlier about a systems-based business. All of our offers, all of our leases, everything is systems based. So we create a system, we do everything the same way each time. That helps us defend, potential issues for fair housing, treating people equitably, things like that. We just ask everybody the same question. So now you can see up here our seller listing template, our buyer offer template. I just updated these yesterday morning, actually. I did a class for the Department of Real Estate on the RPA. And then again, I just did the podcast for them last Friday. I have a lease template. I've got, here's my property management template. Obviously today's the 14th. So down here, I can see that's the one we were just in a second ago. So I'm going to go ahead and click on that because I want to show you the guts of what this looks like. And I would recommend that, again, that you create templates in your program. And here's why. Because when C.A.R. updates the forms, they do it twice a year. We're usually updating the forms because we know what the laws are going to be on the 1st of January and then again on the 1st of July. And by the way, I've already downloaded the new laws. If anybody's interested in that, I'm more than happy to share that with you. Let me see if I can I find, no, I don't want to change screens because if I do that, I won't get back to where I am right now. Anyway, I'll send you the new laws if you want them. Just send me an email. I'm happy to do that for you, okay? So this is what our template looks like. So again, anyway, they will update the form. So over here on the right-hand side where it says all forms, when C.A.R. is ready, they will go ahead and they will update all of these forms. Okay. But that's going to happen when? Well, it's going to happen in December. So here's my form update for 6/23, and that will be replaced with 12/23 when they update the forms in December. Is everybody good with that? So I'll know that what forms there are and which ones they've updated in the library, but all of the forms will be updated if that's appropriate. Now, in my templates, they will update my forms in my template. They won't add new forms. So Linda and I were talking, Linda's my broker, we were talking this morning about that. You know, when the buyer representation agreement, the previous version of it, when it was replaced with the BRBC, remember we had 3 buyer representation agreements, and then we consolidated all that into one, and we called that the buyer representation broker compensation agreement. And when we did that, they removed the BRE from our template for our buyer offer, but they don't put forms back in there. So they did not replace it with the BRBC. So that's what I look for, you know, twice a year is, do I have all of the, are all my forms in the library? So when I went to my buyer offer template, I could see that it was missing the BRE had been taken out. I needed to add the BRBC. Okay, everybody good with that? So it's really the process of maintaining your templates is not as onerous as people think. Okay, and again, I'll provide you with my templates. You just let me know, what you want. You got to send me an email. I'm happy to help you in any way that I can. So looking at this part here, I can see that I'm in my folders, all right, and I'm in a template now. So I would apply this template to a real estate transaction if I was going to do a property management transaction. So I see I have 4 folders and 1 subfolder. So my first folder is going to be my PMA, which is going to stand for my property management agreement. I'm going to click on that. So here's what I get when I go out and I take a listing on a property management agreement, okay? And then my second set is going to be my lease agreement. And that's what happens, as we said, we're going to talk about this. Here's my lease listing agreement. Here's my residential month-to-month agreement, rental agreement, and then I have all my animal terms and conditions and things like that in there. Then I have my notices to the tenant. So we have a number of notices. And by the way, San Diego has a more restrictive Tenant Protection Act than California does. California created statewide rent control, obviously for political reasons, a couple of years ago. And then San Diego in May the 13th, actually, of this year, San Diego jumped in and created their own even more restrictive version. So thank you to Luda, who actually turned me on to that, which was really nice of you, Luda. Thank you so much. And so let me just show you. This is the City of San Diego's Tenant Protection Act, or Protection Guide, they call it. They're calling it July of 23, even though they voted on it in May 13th of 23. And so it's a fairly extensive document. Let me see, it's 18 pages. I would recommend that you go through it, read it, and make sure that you are in compliance if you are doing property management in San Diego. So it explains, their idea of just cause is different than California's idea of just cause. And again, they can't make rules that are more liberal than the state rule, but they can make rules that are more restrictive than the state rule. So tenancy, so here's an answer to a question that I got earlier. So it limits the amount your rent can be increased, et cetera. Includes a copy of the tenant protection guide. So tenancy existing before June 24th of 23. Notice with the tenant protection guide shall be provided to the tenant directly or as a lease addendum within 90 days. Starting after June the 24th, shall be included in the lease or as a written notice the tenant signs at the time the lease is signed, with a copy provided to the tenant. So the important thing is that in this case, they're actually asking for you to give a copy to the tenant at the time that the lease is signed, which is inconsistent with advice I gave yesterday. So I probably should have, reviewed that really quick. But you got to give them a copy of it. I think essentially you're giving them a case, right? And I think that that's just the way that it is in San Diego. So, but it goes through all kinds of interesting stuff in here. So I'll make a note to fix that problem I created myself. Okay, so that. And ultimately, I'm going to load that. In fact, notices to the tenant. Let's go ahead and add the document. I'm going to click on Add Document. I'm going to click on Browse for the document. And then let's see here. I don't think you want to see all my photos and pictures. I'm going to go down here to S.C.A.R. I'm going to go to webinars. I'm going to go to my property management forms. And then the most recent thing was my tenant protection guide. So I'm going to load that into my template so that I know I'm going to provide that to the tenant upon a lease that I created, obviously after June of 24. And so I'm going to go ahead. I'm going to click the organize button because I'm literally going to move this down to the bottom of the queue. I want to make sure that it's there, but that's how I'm also showing you a little bit about how to do that. That's kind of what my purpose is with all of this here. Okay, so move that up, and that's it. I'm going to hit my done organizing button. And so note to self, I need to send this out to a couple of properties that I'm involved in right now. So this is my notices to the tenant part of things. And these are all the notices that I give the tenant. And then finally, I have my disclosures and advisories, and we're going to drill into these. My disclosures and advisories, these are the things that some of these are already included with the lease. Like, for example, the bed bug disclosure is already included. The California version of the rent mold ventilation addendum is already included. But we wouldn't include housing provider in default unless, in fact, the owner of the property was in default, right? There's my MCN, there's my burn form, all those things. So I'm not going to be able to open up all of these forms today, but we are going to discuss the key elements of them. So down here underneath my disclosures and advisories, I have my environmental window, and this is the 1, 2, 3, 4, 5, 6 of the environmental hazards booklet. And remember, the law requires a statutory requirement that you make that disclosure to the tenant prior to occupying the property. Okay, questions about any of that? Any of that so far? Okay, good. Then let's go back up to my let's go back up to the main folder. I want to well, let me just get us there quick. So there are some other things that really didn't have a place to go into, receipts for reports, my Megan's Law disclosure. Probably that should go under disclosures and advisories. So I'm going to move that one up to disclosures and advisories. And it's not going to be environmental. It's going to be in the other one. I've got cash for keys, I've got arbitration agreements, things like that. Okay, so let's start off with my PMA folder. I'm going to click on that really quick. Let's take a look at my property management agreement. And again, at any point, if you have questions about any of this, please stop me. I do look forward to the questions, okay? And if you haven't gotten into using the new version of zip forms, it's actually kind of interesting. I don't have a problem with it. It's got some good things that are associated with it, but that'll be this afternoon's class. So I'm going to go ahead and close that, taking me back to the form itself. The downside of it, unfortunately for me, is that I'm not able to highlight things like I was in the previous iterations of the program. But we're just going to have to deal with that. So there's that first form, right? The disclosure regarding real estate agency relationship. Again, the law requires you to disclose the concept of agency prior to committing conduct that constitutes agency. And the law says you clearly have to disclose agency where there's a leasehold interest over here exceeding 1 year per Civil Code 2079. Again, Civil Code 2079 is the civil code that addresses us as real estate licensees. So you really should have a good idea of what is going on in 2079, as we say. So if checked, then this form is used in that purpose. I'm going to check it. I'm just going to use the form anyway, because I think you really should. And that's my agency disclosure. Okay. So let me take us down. We did talk briefly about the Fair Housing and Discrimination Advisory. Again, make sure you're using the current form. This is 6 of 23, and the really only changes to it were we made some changes. They actually didn't make enough changes, but housing provider now rather than landlord, So, but you're still seeing references to landlord. Landlord, I guess, was held to be kind of derogatory, I guess. We don't call the tenant the serf or the thief or anything like that, but comes from the Old English, right? Okay, so that's my Fair Housing Discrimination Advisory form. And then there's my property management agreement. So let's talk a little bit about the property management agreement. Now, I want to make note, it says right at the top of the form, this is the property management agreement. This form is not binding on the broker unless signed by a broker, Luda, or office manager on the broker's behalf. So you as the licensee in putting this together need to understand that the broker must sign off on it, or an office manager, or on behalf of the broker. Okay, so in our office, Linda is our broker. I am the supervising broker, the managing broker. Give me a title, go ahead, I don't care. But I'm usually the one you got to go through when things are going wrong. So that being said, let's go ahead and obviously I don't want to do a class on contract law, but please stop me if you have a question about something. So I've got my date prepared, much like all of our other forms. I've got the name of the brokerage, whatever that is. I made that up. Property Management Inc. Appointment of the broker, the RPO. So we learned up here at the top, let me get myself out of the way there. Up here at the top, we learned that my RPO is my rental property owner. So that is the owner of the property giving, employing and granting. This is my employees and grants language down here in 1A. That's the language the Department of Real Estate is looking for. And that's the part that gives the manager, the property manager, specific authority to conduct property management on behalf of another. Okay, so the RPO up here is my rental property owner, and then the broker here and after the property manager gets to do all these cool things. And so it's going to be managing the property known as, but also any additional property that may be later added to this agreement upon the terms below for the period beginning and a starting and an ending date. And so remember that the law likes a date certain. So they clearly, the Department of Real Estate comes into your office, they're going to be looking for a starting and an ending date on all of your listing agreements. I have done DRE review where I've gone in and pulled a file and they don't have starting and ending dates. And I asked the broker, I say, well, what's that all about? Well, we wanted to be able to extend it or do whatever, at leisure. It's an incomplete contract. It's probably, in my non-legal opinion, unenforceable against the parties, and the DRE can take your license for that. So we want to make sure that they all have firm beginning and ending dates, no 30 days or 45 days, and that's just a principle of contract law. After the exclusive term expires, the agreement shall continue as a non-exclusive agreement, which means you can list with somebody else, you do whatever you want to do, that either party may terminate by giving at least 30 days written notice to the other. Okay, all right. So that's the appointment of the broker, and then of course in our office at least, we do check this box on I'm sorry, back up. We don't check the box on early termination. We don't believe in giving them an opportunity to early terminate. We like B2, which says either party may terminate upon written notice for cause. And so normally written notice is 30 days, again, for cause. If you tell people they can terminate something early, then they will do it. They'll take advantage of it. I've had people terminate listing agreements on property when I was management for other brokerages because the agent had told them they could. So so now remember, contract. I just want to bring a point out here. Notice that the contract is in paragraphs, number 1, number 2, number 3. So remember that lawyers put these together, and lawyers think in terms of outlines. So the idea, part of the idea being the law of severalty, which says that if one part of the contract is held to be invalid by a court, then the rest of it shall still remain valid. That's why it's not one great big run-on sentence. And that's why we do it this way. So paragraph number 2, property manager acceptance. 3 is authority and powers, et cetera, et cetera. Okay. So when I did my RPA class, I literally broke down all these paragraphs into an outline, and then I explained each one of them. And so my dissertation, I guess you would call it, was 36 pages long on the RPA. Okay. So the DRE says when you're going to get your class approved, you've got to write 3 pages for every hour of instruction. And since my class was for 5 hours, I had to write 15 pages, and I just couldn't contain myself within 15 pages. So property manager's acceptance up at the top accepts the appointment and grant. Remember, employees and grant. I accept the appointment and grant, and I agree to use due diligence in the performance of this agreement. So this is called the quid pro quo. In exchange for you asking me to do this, I promise to do these things. And then furnish the services, et cetera, et cetera, et cetera, at the reasonable discretion of the property manager. And reasonable is a standard of law. It's called the reasonable man standard. That's kind of an old saying as well, obviously. And that is, what would the reasonable person do? And that's usually a decision for the judge to make. And so we don't want to get to that point where we've got the guy or the gal in the robe who are making decisions, because once we get there, it's cost us an awful lot of money. So we try to work that out before we get there. Okay. Authority and power. So the RPO grants the property manager the authority and power at the RPO's expense, so at their expense, to advertise the property, to rent, lease, and then we're going to talk about direct electronic payments here. And so a lease or agreement executed by the property manager shall not exceed 1, 2, 3, 4 years. I think reasonably, I probably wouldn't do the lease part of things. I probably wouldn't do for more than 2 years. But remember, you also going to have a duty to amend your lease if the laws change during the lease period. Now, I say that, and I just leased a property that Linda owns for 2 years. They wanted to be in the school district for 2 years. And I think, frankly, they realized we were giving them a really good price on the rent. And so they wanted to lock that in for 2 years. And we did not have an escalation clause in there. So it didn't really matter. We were looking for a good tenant. There were other things that were going on at the time. Or it can be month to month. Again, property management can lend itself to month more so than a lease agreement. Long-term lease agreement might do so. So unless the RPO authorizes a lower amount, rent's going to be either market rate or a minimum of X, or we can have an attachment. During the racing season, it'll be $50,000. During the off season, it'll be $2,000, whatever. Okay. All right. If the RPO permits the tenant to pay rent by direct deposit, such as wire or electronic payment, RPO should discuss with the landlord tenant attorney the implications of doing so in the event that the tenant defaults and an eviction becomes necessary. And so why is that? And the reason is because when you collect rent checks from a tenant, those checks are susceptible to the NSF laws, so the insufficient funds laws, but you don't have those protections with electronic payments. So you have them with checks. On that note, I wouldn't accept more than a check a month, because your lease agreement is going to say that it's good for a year, and the collection of rents on a monthly basis is an accommodation to the tenant only. And so You really don't want tenants coming in and giving you December, January, and February, because the NSF laws apply to the December payment, but they don't apply to the January and the February payment. Those are treated as promissory notes. Again, this is why we want you to talk to counsel. We want you to talk to an attorney about that. Okay, so flying right along in here, I'm going to speed it up a little bit. And again, please, if you have a question, ask. Termination. We can sign and serve in the RPO's names notices that are appropriate to do that. Repair and maintenance. You are authorizing us to do this work. Reports, notices, and signs. Obviously, we can post. Broker and third-party vendor services. So the RPO is giving the property manager the power to supervise the activities of those people that are hired by the RPO. Expense payments, very important. I have this conversation with people a lot, and that is, who pays for what? Well, what did you check? So the default language says that the rental property owner pays for everything, but some of these things you might pick up. You might decide, I'll take care of the HOA dues, and so at that point, I'm going to check that appropriate box. Okay. All right, limitations on payments and then the exceptions. And so again, the property manager says, I want to put a limit on how much I can spend on your behalf every month, whatever that number is. I've seen $5,000, $10,000, $20,000. I've rarely ever seen $50 because obviously, if you're handling a number of properties, it's going to become incredibly inconvenient. For any occupancy, total expenses, any vacancy, total expenses shall not exceed a certain amount of money per vacant unit. And then when I get down to my security deposits, where are you going to put the security deposits? Are you going to put that in your trust account, or are you going to give that to the RPO? I would recommend that you put it in your trust account. If you give it to the RPO, you need to make sure that the tenant is aware that that's where the money is. By the way, if the owner demands the tenants, the security deposits that you have in your trust account, you must also immediately notify the tenant of the fact that that was transferred to the owner themselves. Okay. All right. So trust funds, again, deposit all receipts collected for the RPO, et cetera, et cetera. Property manager shall not be liable in the event of a bankruptcy or default of a financial institution. Reserves. So again, the RPO is going to be required to leave a certain amount of money, kind of like a retainer, in that property manager's trust account for that particular property. Okay, this is why your bookkeeping has to be really good. Okay, so disbursements. And again, this is the order in which we're going to disperse the money. Obviously, the first one that gets paid is you, the property manager, and then it goes all the way down to the very end when the RPO gets what's left. Distributions, I would recommend quarterly, at least. I wouldn't do them longer than that. And then statements quarterly, I'd probably do it that way. Property managers trust funds, it's very, very important. Remember, the Department of Real Estate says you may not put in more than $200 of your own money into the account, and that's because it is the count of others. And so the $200 is intended to offset bank charges and things like that. Remember, if you put in more than $200, you're probably going to go for commingling funds. And then part of the problem with that is that when you go to spend any of that money, since nobody really knows which of it was your money and which of it was the owner's money, now you're going to have commingling. And so both of those are on the state exam, and I would definitely tell you, probably know the limits, especially if they change. Know what those limits are as to how much of your own money you can have in there. Okay. All right. And remember, you have to have a zero balance, on that account. It's a zero balance account. Key safe lockbox, have them sign the KLA form. Mail forwarding, this is interesting, paragraph 3Q. Under no circumstances shall the property manager be responsible for the forwarding of any mail directed to any previous occupant, all of which may be refused and returned to sender, not discarded, but refused. Moved, left no forwarding address, whatever. Okay. All right. Rental property owner responsibilities. This is going to go through the list of all the things that the rental property owner is going to be expected to do. The owner is also going to agree to complete the RPOD, which we're going to go through. And we're going to have two forms. One's an RPOD, one's an RPOQ. Again, the Q shall be provided to the broker within 3 days of completing the agreement. I think it should happen at the time of the agreement. And then the RPO authorizes the broker to provide the tenant with the RPOD, not the RPOQ. Okay, anybody have any questions about that? We're going to go through the RPOD and Q in a second. Okay, my favorite phrase, 4C, indemnify, defend, and hold harmless the property manager. Okay, unless of course the property manager breaks the law somehow, in which case there's no obligation to defend me for an illegal act on my part, that kind of thing. Okay. All right. Anything else in there exciting? I think that's going to be good for now. Maintain the property in a condition fit for human habitation, and again, that's Civil Code 1941. And then pay all interest on tenant security deposit if required by law. Carry and pay for insurance. So we want to know we got at least $1 million. And this is the rental property owner's insurance, right? That we want them to have at least $1 million worth of coverage. Again, back up here, rental property owner responsibilities. At least have $1 million in coverage on the property that indemnifies the property manager as well. And again, if they don't do that, then they've authorized the property manager to get it for them, pay late fees, etc. Immediately replace any funds required if there are insufficient funds in the property manager's trust account. Remember, you're not allowed to put in money to make up the difference, make up the shortage. Okay. All right, RPO representations. I represent that the RPO represents that they're unaware of a notice of default affecting the property, any delinquent amounts due under any loan, any bankruptcy, insolvency, et cetera, any litigation, arbitration, administrative action, any current pending or proposed special assessments. They will notify the property manager in writing if any of the above ends up happening. Here's the tricky one. Paragraph number 6 talks about tax withholding, and so we have a couple of laws, and one of the laws is California law. California law says that for purposes of property management, if the owner is not, if the RPO is not California FIRPTA, which means they don't live in California, they don't reside, the money's not going into California, then you are, as property manager, are required to withhold 7% of the gross payments. The ones that you're going to make to the RPO that exceed $1,500 in a calendar year. And so there are some forms that the owner can fill out and provide you with. Again, they need to talk to their tax people about that because that's tax form. You don't give tax advice. Most people are able to do that. But the second part of that is the U.S. FIRPTA, which is 30% of the gross rental receipts. And then again, we're going to have an obligation to withhold those funds if they're not a U.S. citizen. Clearly, if they're not, if they don't qualify under FIRPTA, the U.S. FIRPTA, then they're not going to qualify for California FIRPTA either, right? They could qualify for California. If they qualify for California, then they're qualified for U.S. But they could be not qualified for California and still be qualified for U.S. Okay. All right, so all of a sudden you become a taxing entity. So, or at least a collection of you're not a taxing entity, a collection of tax entity. Broker has a legal duty, and you want to point this out to your client, to report rental income received at tax collection agencies via IRS Form 1099. Okay. All right, compensation. Would you like to get paid for your services? And the answer is, this is the time to talk about that. Okay, so you need to go through this. What are you going to charge for? You have to tell them what you're going to charge them for in order to be able to charge them. So again, if you are contemplating that you're in property management, this form is, I think, an exceptional form. I'm going to charge them for management. I'm going to charge them for renting or leasing. I'm going to charge them for evictions, in addition to any attorney's fees and court costs. Preparation, I charge personally for trial work. Whenever I'm going to have to do a trial, whenever I'm going to have to go to court. People outside my house here. What's that all about? I charge for my work in determining whether or not there's a potential, whatever I'm going to have to fill out. So participate in an eviction proceeding. If I have to leave the office and go into court, I'm going to charge for that as well. And so that's why I say, make sure, be aware, you're probably going to spend some time in small claims court. I mean, just by virtue of having the, doing property management, preparing property for rental or lease, managing the property during extended periods of vacancy. You can charge for these things, but you've got to tell them whatever that's going to be. Onboarding, setup fees, things like that. You have to tell them what you're going to charge them. Cancellation fee. So if there's a cancellation fee by either one party to the other, how much is that fee going to be during the term, at any other time? And then what about my offboarding or file preparation and file closing fee? You're going to have time into this, and you're going to have expenses into this. And so for me, I charge for that time. I charge for those expenses. And so I always tell everybody, I'm $4.50 an hour at trial, but I'm significantly less than that if you want to just set something up ahead of time. Okay. And I set up brokerages, I do things like that. So I am happy to help. Tax withholding and reporting if I'm going to charge for that. So this agreement does not include providing on-site management services. So I'm not a resident property manager. You don't need a real estate license to be a resident property manager. That is someone who is living in the property and managing it for a company, for example. If you are a resident property manager, you don't need to have a real estate license for that. So, the minute you go across the street to show another property, and it's not owned by the same party, then you are doing property management and an activity that requires a real estate license. Okay. All right. Let's see. RPO further agrees that property manager may receive and keep fees charged from tenants, et cetera, late payments, et cetera. Property managers shall disclose to the RPO any other relationships as they occur, if any. So in other words, I own the plumbing company, or I have a financial interest in the plumbing company, much like you see in sales, right? If you have a financial interest in something, you need to disclose that to the owner of the property that you're going to have. Otherwise, you have what's called secret income. So law refers to it as secret profit. And so we don't want to be doing that. Paragraph number 8 talks about my agency relationships. Chances are pretty good as a property manager, you're going to probably do both sides of the transaction. Notices. So where are we going to send the notices? First class mail to the address below, or any different address may later designate, or to the following email address. I'm all about email. If we've been corresponding by a certain email address, then I'm probably going to want to keep doing things that way. Security insurance. Property managers are not responsible for damage to the property, personal or otherwise, or persons, etc. Attorney's fees. Notice that we've changed a lot of what we're doing for attorney's fees in the state level. California Association of Realtors, we're going more and more towards each party paying their own fee. So in this case, RPO and the property manager, each responsible for paying their own attorney's fees and costs. And the intent behind that is to discourage litigation. We're trying to, quell the number of lawsuits, in the day, which is not that long back. People would, hire the $750 an hour attorney, and then their job was, of course, to try to kick it down the road until they got paid for it. So it can be very, very expensive. Notice only the RPO is initialing these pages. So dispute resolution. So mediation always first. In all the C.A.R. forms, we want to encourage people to try to work things out. If you jump ahead of mediation, and so here it says, any party commences an action without first attempting to resolve the matter through mediation, or before commencement of an action refuses to mediate after request has been made, and that party is the losing party, then the prevailing party shall be entitled to recover attorney's fees. Okay, so that's that exception to, we say we're going to each pay our own, but if you skip mediation, we can go after you for your attorney's fees that we ended up having to spend to defend. Okay, all right. Additional terms, obviously exclusions, small claims court, unlawful detainer, things like that. And then we have an ARB form, which is the arbitration agreement form, which, one of the reasons we took the arbitration provision out of all of the listing agreements, not the purchase agreements, but the listing agreements, was because the agents were obligating the owner or I'm sorry, the broker to arbitrate, and by just because there was a place to initial it, which I always have a problem with, people just initialing it because it has a place to initial it. And so the brokers were coming back and saying, hey, you know what, we didn't want to arbitrate, we wanted to litigate. It's more fun for us. And me personally, I love, I'd rather be in court, right? But arbitration's a faster track, and sometimes you get the same lousy decision in less time. So so the brokers were just saying, hey, we don't want to do that. So we took it out of the agreement, and now we've added it as a separate form. So if you want it to apply, you have that separate form. Equal housing opportunity, modification of the agreement. So this is a twist on things now too. The property manager may modify by first providing 30 days or whatever written notice to the RPO. If the RPO objects to the modified terms, property manager may either rescind the modification or allow the RPO to terminate. And if you allow the RPO to terminate, then you may not charge a cancellation fee. It's because you instituted the change. Is everybody okay with that? I just want to make sure we covered that. Additional terms, obviously the RPOD, fair housing, CCPA, and then my agency disclosure forms. Time of essence, that's a term of contract that just says that that time periods will be strictly construed, which means that if we say 17 days, we mean 17 days. We don't mean whenever, 20 days, 30 days. We don't mean that. We mean 17 days. Okay. All right. And then obviously our parole evidence rule, don't be making statements that are inconsistent with the contract. That's something I get a lot of. And then let's see, one of my favorites, Lynn and I talked about this morning. So I've got a PRBS with my buyer, you've got a PRBS with your seller. Do we both need to be signing each other's forms? And the answer is no, as long as the forms are identical. So the last sentence in here, this agreement and any supplement, addendum, or modification, including any copy, may be signed in two or more counterparts. So it's called counterpart or countersignature, all of which shall constitute one and the same writing. So as long as they're the same form, and I can hold the two PRBSs up to the light, seller signed up here, buyer signed down here, as long as they're the same form, then I have everything I need. I don't need to sign again. And again, that's just another principle of law. Legally authorized signer, the person that is signing on behalf of another, has to provide proof of that within 3 days after execution of the agreement. Ownership, title, and authority. My advice to you would be to never leave a blank. So in here, I'm going to change or as follows, NA, because I don't want people filling in a blank above a signature or above initial. It's also fraud, but people do it. So so I would recommend that you always, Luda, you always want to fill in the blank. Okay, does everybody understand that? Oh, Luda left. All right. Okay. All right. So she could only stay for 40 minutes. So okay, so that being said, again, that's my principle, is never leave a blank. Okay. Entity rental property owner. So when my RPO is someone other than signing for someone other than themselves. So that could be they have a power of attorney, a trust, a corporation, a LLC, whatever. Anytime someone signs on behalf of someone other than themselves, now we have what the law refers to as a non-natural person. And so at that point, if I fill in the RCSD here, then that satisfies the requirement. I don't need an additional form. So if this paragraph is completed, an RCSD is not required for the legally authorized signers designated below. Why? Because this is the RCSD. So we added that RCSD that was a separate form for a long time. We added that into each of our agreements. And again, this should say RCSD LL, landlord, but we got rid of the word landlord. Remember that? So, okay. All right. And then they sign it, trustee if applicable. So however the name appears on the trust, that's what needs to go in here. Okay, so printed name of the RPO, signed by someone else. Okay, that's okay, but the name as it appears. And so again, if it's a trust or under probate, the following is the full name of the trust or probate case. And probate case will have a case number as well. Okay, but the probate, but again, the trust will have a date associated with it. So that full name needs to be in there. And up here, when I check this box, watch what happens to all these fields. I go click, and then all these fields become available. Okay. And then down here, printed name of legally authorized signer. So when I uncheck it, all those fields go away. Okay, all right, everybody good. And then of course the broker signs it down here. And again, I've just got my name in there as a placeholder. But wait a minute, there's more. So we've got our rental property owner disclosure. And again, intended to be provided with a lease listing or property management agreement and with a residential lease. So this is going to be something that we can provide to the tenant, the RPOD. The RPOQ does not get provided to the tenant. So again, rental property owner, notice it looks vaguely similar to the seller property questionnaire, and then of course the seller property questionnaire addendum in San Diego. Here's my limitations of liability, and a lot of the same stuff. I won't go through all these line by line. Paragraph number 5, again, a statutory requirement if the property was constructed prior to 1978. Okay, you don't want to make this mistake, all right? And notice that the owner will fill in the fields, not the agent, not the property manager. Technically speaking, I know I got this question yesterday. Should the property manager be filling that out? And I would say the answer to that is no. We need at least to get that done up front by the RPO. Okay, so lead-based paint, any renovations, subject to the lead-based paint renovation rule. That's my six feet of interior space, 20 feet of exterior space. My meth contamination, my periodic pest control. These are all statutory requirements. Water submeters, again, there we go, Civil Code 1954. Mold, there really is no standard for what is toxic mold or anything like that. My graduate certificate in hazardous materials management, we realized we never really did set a bar because it's different for different people. Asbestos, HOA, military ordinance. Oops, we got an error here. I'll have to get a hold of C.A.R. Paragraph number 12, that should not have an I in it. An I, ordinance is a rule or regulation. And so, in fact, I had corrected that on the SPQ originally. So I'll let them know about the RPOD. Death on the premises, again, a statutory requirement, Civil Code 1710, any other material fact. And then they sign it, and then we're off to the races. Here's my CCPA. Again, use the current version, 12 of 22. And then that'll round out my property management agreement. Everybody good with that? I'm going to hit my back button, and it's going to take me back to the next form that we're going to look for. So we've covered pretty much, these are all the forms that I have in my property management agreement with the owner, maybe not the vacation rental. But again, I will send all these to you. So just to kind of give you an idea, when I pull up my file, this is what it looks like. So all these forms, let me go ahead and do them by name. My agency disclosure, here's my environmental forms, here's my water heater. So I'll send all these to you if you want. But again, I'm doing this live in zip forms so that I know I have the current version. Notice these were all dated March of 6, and some of these were updated. In fact, I'll probably end up saving these because I have forms from back 40 years ago. But I just wanted you to be aware of the fact that those forms are out there. So, okay, that being said, we'll go back up here. I'm going to go into my lease agreement. So we covered the property management agreement. Now I want to cover the lease agreement. So what am I? Oh, I'm sorry, I missed one thing. So the listing agreement, where is that? Property management. Oh, that's interesting. I don't have it in there. So I don't have property management, the listing agreement in there. Let's talk about I have it over here. Why do I have it over there? I don't know. So let me go ahead. I'm going to move it once again, move, and then I'm going to take it up and put it into my PMA forms. Boom, away it goes. So that was my listing agreement. So let's go back up and let's take a look at the listing agreement. And then that'll give us time, and we'll come back down and look at the actual lease agreement itself. So this is my listing agreement. This afternoon, I'm going to teach you how to do all these other courses, or all these other, how to create workspaces and things like that. But here's my lease listing agreement. And so a lot of the same principles apply: beginning and ending date, address of the property, rental amount, how much is that going to be, security deposit. This is if you're doing this for an individual property, okay? What's the rent amount? What's the security deposit? What's the type of tenancy? Month to month, 1 year, other. items that are included in the lease rental. And so you want the owner, when they list the property with you, to tell you what is going to be included in the lease. Personal property, personal, not real, that will not be maintained or replaced by the RPO. This used to be like question 17 on the form. And then items excluded from the rental. I've had that happen where the owner of the property, what was it, 280 Surfview Court. I leased it for many years for the owner, and he refused to let the tenant get into the garage. He had his BMW 7 Series in there, and he didn't want to get it scratched. So the tenants that rented the property did it without a garage. Problem was, in that area, you had to park a ways away from the unit to be able to do it. So that being said, paragraph number 3, we talk about the money. Again, this is the lease listing agreement. You don't really want to create terms that are inconsistent with the property management agreement. Remember that the law requires, and I had this conversation with a broker last night, they put in a counter offer that the commissions would be 2.5%. So the DRE's position on this is any money that you collect, whatever you call it, is going to be considered a commission, and that must be somewhere near this language that says that the amount or rate of real estate commissions is not fixed by law. So the amount being $1, the rate being a percentage, are not fixed by law. They're set by each broker individually, may be negotiable, whatever. Okay. So then paragraph number A talks about fixed leases. You put in whatever figure your broker tells you to do. Or additional compensation, if any. Month-to-month rentals, how much is that going to be? So a short-term rental for either a fixed or month-to-month. We want to make sure we get compensated in the event that somebody takes possession of the property. Paragraph A3B is what the Department of Real Estate refers to as the safety clause or the protection clause. And so this is where you would put in a number of days. We put in 90, you put in whatever you feel is necessary. But if the listing expires, we want to protect ourselves to potential tenants, that the owner may lease to, that we show the property to, so that we otherwise physically introduce right here, who physically entered, was shown the premises during the listing period, for whom the broker submitted an offer, of course, then we're procuring cause. However, no obligation to the broker unless no later than the end of the listing period, which is how we changed our listing agreements. Generally, we've got to give them a name of prospective transferees, and of course we have a form for that, and that's the notice of introduced parties and NIP form. And then finally, C, if you otherwise make the property unmarketable, then you owe us a commission. Okay, real simple. All right. Okay. B, if commencement of the lease is prevented by a party to the transaction other than the RPO, and then the RPO goes after those people and is successful, then we're entitled to an amount equal to the lesser of 1/2 of the damages or the above compensation, whichever is less, the lesser of 1/2. Okay. C, the RPO could agree to pay additional figures. D, broker may retain compensation due for move-in payments if necessary. And then E, so what happens if the tenant purchases the property? You would have to check this box. You would have to put in a percentage amount down here. I think it should be a dollar or a percentage amount, but it is what it is. Put in whatever that figure is going to be in the event that the owner ultimately sells the property to the tenant. Okay, everybody good with that? Any questions about any of that so far? We'll get into F. We're doing pretty good. We're going to get out of here on time. My tea has become iced tea. Okay, so paragraph number F, how much do we pay the cooperating broker, somebody that comes in? Remember, there's no minimum, no maximum. And as a result of the Burnett case, I'm starting to see a lot of people putting in the MLS, 2%, 1%, $500. But our MLSs actually have no minimum. So that's the way that they're being changed across the country. Bright MLS, which is one of the largest MLSs on the Eastern Seaboard, recently they had required a $1 minimum commission. They have changed all that and said, nope, we've got to put 0 in there. So there is no obligation to pay the cooperating broker. Again, it would behoove the cooperating broker to have an agreement with their tenant to pay them. Okay, all right. But here's where we put how much we're going to pay the other side. And then paragraph number G says that the RPO tells us that they don't have an obligation to pay anybody other than us, unless the property is leased or rented too. So remember, notice of introduced parties in there. So we would want to put the names of those people in there. If in fact they do lease it to those people, G2 says you don't owe us compensation and we don't have to represent you either way. Okay, so make sure, folks, that you ask those questions when you take the listing. And this is the part that gets missed. You need to ask the questions of the owner. Do you have an obligation to pay anybody else? And they're not going to know what that means. You're going to say, do you have the property listed to anybody else? Did you have anybody? Was there a period of time where they provided you a list of names? Again, it has to fall within the purview of the safety clause, and that's your job, because we don't want to be blindsiding owners of property and charging them for things that they would not otherwise have to pay. Tenant payments, and so where's that going to go? First month's rent, where's it going to go? To the broker to do an execution upon possession? What? Same thing with a security deposit. Again, this is the listing agreement, okay? And then finally, 4B is my direct electronic payments. And again, the same language we saw before about they need to consult with a landlord, tenant, attorney. I'm not a big fan of electronic deposits. I can tell you that I've had some significant problems with various banks over those electronic deposits. I'm sad to say our information is not quite as secure as we think it is. So I don't know if I would do that, but you do whatever your broker tells you to do. KLA form, again, my key safe lockbox addendum, only because we have to let the owner and the prospective tenant know that we don't have insurance to cover your toys. And so I just never forget. I had about 25 years ago, I had a tenant send a company that I was managing for a letter saying that somebody stole their Rolex, and it was ROLECKS Rolex. And of course, that's not how you spell Rolex. So I kind of assumed that they really never owned a Rolex, but all right. Sign. So by default, I'm sorry. You need to check the box if you want to install a sign. If you don't check the box, you may not put up a sign. That's a DRE violation. Okay. MLS listing service is going to be provided in the MLS. There's a lot of advantages for doing that. Security and insurance, again, we're not responsible for any loss. Broker does not maintain insurance to protect the RPO. Ownership, title, and authority. The owner's telling us at the time of the listing that, I'm the owner. I do all of that stuff. Nobody else has the power to jump in front of me. Okay. RPO representations, again, same as we saw before about notices of default, delinquent amounts, things like that. Tax withholding, again, same thing you saw in the property management agreement. Brokers and RPOs duties, same kind of thing. Same thing you saw in the property management agreement. And then, again, there's my favorite, agrees to indemnify, defend, and hold harmless the broker. Paragraph number 13 goes into my agency disclosures, 13A. And then 13B just authorizes us to represent the RPO in a resulting transaction. C talks about possible dual agency. Again, if you're doing property management, it's highly likely that you'll be a dual agent. You don't have to accept that, by the way. I had one recently where it was clear that you didn't want to represent the tenant. And so you got a buyer non-agency agreement signed with the tenant, which disavowed agency with the tenant. They had the right to go get their own broker. They chose not to do that, but you were not their agent, which lowers your liability considerably. Okay. Other RPOs, the equivalent of our PRBS form. Confirmation, we're going to confirm agency here. Termination of the agency relationship. So this is something I wanted to make sure I brought up to you, and that's because when does on a regular listing, not on property management, but on a regular listing, when does your agency relationship terminate? So much like a sale. So when I sell a property, and I get this call from people, they call me up and they say the seller's agent is soliciting my client. I'm the buyer's agent soliciting my client. And I say, well, did the transaction close escrow? And the answer is yes, it did. Well, then you don't have a client anymore. And that's something that a lot of people, it just escapes them, right? Because once you have sold property, all right. And in this case, once we've determined when agency is up, you don't have a client anymore. So yeah, the seller's agent, is no longer the seller's agent. It's just somebody else soliciting, people that own property in the area. So there is no violation of any kind really there. So what happens? What constitutes termination? So it says here, RPO further agrees representation duties and agency relationship, right? With the broker terminated at the earlier of I or little II. So entering into a rental or lease agreement, okay, that would be the end of it by default. And if checked, tenant occupancy, delivering keys. I personally like delivering keys. Once I give the keys over in California, keys constitutes possession. As I said earlier, that when the tenant comes back to leave the property, they have to surrender the keys. That's surrendering possession of the property. Remember, they don't have an ownership interest, but they do have a possessory interest. I have had it happen personally where the tenant will say, I'll give you the keys when you give me my deposit back. And we're going to see in a minute that the law says in California, at least, I've got 21 days to return that deposit. So the longer you hold those keys, the longer you are delaying giving me possession of the property. And so I will start my unlawful detainer at this point. Okay, that kind of thing. That tends to be very encouraging for the tenant to comply. So keys are a big deal. Walkthroughs, completion of what used to be the MEMO form, move in, move out, but now it's the move in form and then a separate move out form. If no lease is already entered into, then at the expiration of this agreement, so agency would terminate if you never leased the property, you never did accomplish the purpose of the listing agreement. Attorney's fees, again, everybody gets to pay for their own. Dispute mediation, etc., same as we talked about before. And arbitration, same thing, separate form. Management approval, so this is new. Well, this has been there all this time, but it's something that you weren't expecting. So if a salesperson or broker associate enters this agreement on the broker's behalf and the broker manager does not approve of its terms, the broker manager has the right to cancel this agreement in writing within 5 calendar days. So the Department of Real Estate gives the management or the broker of the company 5 days by law now to disavow the agreement. Okay, this is why they require that associates, whether they're salespersons or broker associates, provide all of the paperwork to the broker within 3 days. That gives the broker an additional 2 days to decide whether they want to move forward or not with the transaction. And so, but brokerages, much like ours, can limit it to 1 day. We can't make it go 10 days, right? Because that would be violation of the DRE, but we can make it go less time. And so in Linda's office, it's 1 day. Okay. So again, we just can't make it for longer than that. And so the problem arises where the agent provides all the forms to the broker the day before, so that they can get paid, kind of thing. But the real issue was not getting paid. The real issue was that the DRE requires you to give all those forms to the brokerage within 3 days or less by contract with your brokerage. And so you need to look at your agreements with your broker to determine how much time that you have. In most cases, they don't really address it. In our office, we want to get it right away, and we make it easy for the agents to give it to us right away. We use the cloud for a lot of things. Okay, is everybody okay with that? Anybody have any questions about any of that? So the manager's got the manager or the broker, again, because remember this agreement, it said right up the top, the agreement belongs to the brokerage, and they don't have to accept it. but they've got 5 days. Now, if you wait 30 days to give them the paperwork, well, clearly you're in violation, and then they don't have, because the contract says they've got 5 days to get out of it, but you never gave them the contract, so it creates other problems for everybody. Then I've got my, again, this is the listing agreement. I've got my RPOD and my RPOQ. We're going to see when we look at the lease agreement that the RPOQ is fairly similar to the RPOD. Fair housing, consumer protection, disclosure regarding real estate agency relationships. I would probably check that box. Successors and assigns. So again, this is a listing agreement, so it shall be binding upon the RPO and the RPO's successor and assigns. Notice that it doesn't say the broker and the broker's assigns, because you are considered to have a personal services contract, and that is extinguished upon death. So if the broker passes away, then and again, that would be a sole, proprietorship broker, then all the listings expire. And that's a state exam question in California and in Virginia, where I teach it as well. But that's a state exam question. So your personal services contract, upon the broker's death, they're all gone. That's not true for the parties that we have bound to the agreement. So if the owner of the property passes away, then we're going to go after the owner of the property's successors and assigns. Probably shouldn't say it that way, but that's kind of the way it came out. So time of essence again. I've got my signing in counterparts again. And then I go down to my legally authorized signer, same thing we've seen before. And then again, my entity rental property owners. And again, this is my listings of individual properties versus a property management agreement, which may be for multiple properties. Okay, so my RPOD again intended to be provided with a lease listing or property management agreement and with a residential lease. So this is the one that goes to the tenant. So revised 6 of 23. Again, we just went over this a minute ago. I don't need to go through it again, I don't believe. If I do, stop me. But then, and again, this is a complicated process. Look over here. I'm only halfway through the queue. So, but here's my RPOQ. This one is not provided with a residential lease. So this is going to ask questions of the owner that are different than the questions that are going to be asked on the RPOD. Okay. And so I know at first blush, you look at it and you go like, well, which one of those, right? Certain things like carbon monoxide, smoke alarms, things like that. Notice it doesn't say smoke detector. So these are just the listing side of that. But again, this is the listing agreement. Okay. But this is the form we want the owner to fill out that we are going to provide to the prospective tenant. Okay. Most all, trash pickup, lawn watering, pets, keys, mailboxes, laundry, et cetera, et cetera. And that's my RPOQ. That's the one, again, the owner fills it out. It's much less intensive, and that's what goes to the prospective tenant. Then I have my FHDA, my Fair Housing and Discrimination Advisory Form that we've talked about before. And then I have my CCPA again, and that's going to round out my lease listing agreement. So a lot of the same kind of stuff we see in the property management agreement, but in a lease listing agreement, I may be done with it at the time that the tenant takes possession. Property management agreement, how long should those be for? I think 5 years. I mean, surely a year, right? If you're doing year-long leases, I think you're probably okay 3 years to 5 years. The longer the listing term, the more likely you might have to amend your agreement during the term, and the more likely that you will have to come up with ways for early termination of the agreement. Okay, so that's my PMA part. Let's take a look at my lease agreement part, and that's going to be right here, my residential lease month to month, one of my favorite forms. We're going to talk about that. Notice the date here is modified August 17th. I want to get through this, and then we're going to talk about my notices, and then we're going to talk about my disclosures and my advisories really quick. Okay. So this is my residential lease or month-to-month agreement. This is between the owner, us, well, the tenant, whoever that is, right? And either the RPO if we're handling it for someone else, not property management, or the property manager would now be the housing provider. Those are the terms that we've changed. Here's the property again. Following named persons only, I would make sure that you have the actual names of the occupants. As we're going to see in a second, everyone who's going to occupy the property, everyone over the age of consent, over the age of 18, who's going to occupy the property for more than 14 days, they're treated as a guest. We don't want them to be a guest. We want them to be an invitee. I know it doesn't sound like a big deal, but it's a principle of law that says that we can hold them to the lease agreement if they're an invitee. If they're a guest, then they sue us on a whole completely different platform. So again, name the particular people that are going to live in the property. Newborn children. Well, probably not, right? Because they're not going to be the age of consent unless they're going to stay there for 18 years, in which case you will amend them or append them to the lease agreement. So any person in the premises other than those listed in this paragraph are considered guests. So guests are not permitted to stay more than 14 days without the housing provider's written consent. I believe that's in a yearly period of time, not necessarily consecutive 14 days. Okay, so following personal property is included. Again, that you refer to your listing agreement on that. And then property may be subject to local rent control ordinance. And so kudos to Luda, who gave us the San Diego tenant property guide. And that's what I'm going to put in here, the local rent control ordinance that was passed, by the way, on May the 16th by the current administration in San Diego. Term begins on a certain date. And again, if the tenant has not paid all the rents due, no right to possession or keys. Do not give keys until the lease begins. If you give them the keys before the lease begins, they become a guest rather than an invitee again, and we have that whole same problem. Different laws affect what happens if they have a slip and fall, or what happens to them when they're in the property. So agreement is voidable at the option of the housing provider. Let's see, 2 calendar days after giving notice to pay. So in other words, they don't give the rest of the monies. You can give notice to get rid of them. And anything else in there significant? No. So is it a month-to-month tenancy? Again, most real estate agents would prefer it to be a lease agreement. When I was teaching property management, I had quite a few attorneys coming in from both sides of the fence who had opinions about whether or not to do lease agreements with tenants or not. And a lot of times the attorneys would say, I don't want a lease agreement because I want to be able to get rid of them with 30 days notice. Of course, now 60 days notice. But because it's probably going to take an attorney to get rid of a tenant that goes bad on you. Paragraph number 2B, a lease for term, as we say. So you would put in the termination date of the lease. Remember, again, if it's in excess of a year, you got to give them the agency disclosure. Tenant will vacate upon termination of the agreement. Housing provider and tenant have extended this agreement in writing or signed a new agreement, et cetera, et cetera. Let's see. So rent shall be at a rate agreed to, obviously by law. Paragraph number 3, rent also means all monetary obligations under the agreement, except the deposit, and that's so for like late fees and things like that. So tenant agrees to pay X amount of money per month. Rent is payable in advance on the first day. I don't change that. I don't believe California law does not require a grace period. A lot of people think there is one, but there is not one. I leave this as 1 on the first day. And then, as I always say, I serve you on day 2. So if the rent is not paid for by the first of the month, then I'm going to begin the process of evicting you. It's not, you know that the rent is due. And so, people think I'm hardcore about that kind of stuff, but listen, I've had tenants stay with me 15 years, a lot of tenants that stay 15 years. I'm fair with them. I tell them what the rules are up front, and they have a tremendous amount of respect for that. So we have an expectation that we will take care of whatever repairs you need, things that are wrong with the property. We expect the rent to be in on time. And if it's not in on time, we're going to pursue what we have to do by law. If the commencement date, and this is something that comes up frequently, falls on any day other than the first or the day the rent is due, and the tenant has paid 1 full month rent in advance, rent for the second calendar month may be prorated. So in other words, you want to get the first full month up front. So if you today's the 14th, if you lease it to them today, then you're going to charge them rent from today until the 14th of December, and then you can prorate the rest of December if you want to do that. Me personally, I would probably charge them from today through the end of December. That way I've got a month and a half worth of rent. And so then we're not worried about having to, chase them down on the 15th of December. Okay. Let's see. Second calendar month shall be prorated. Tenant shall pay 1/30th. That's referred to as a banker's month. A banker's month means that all months are computed in terms of 30 days. There's no 28, 29, no 31. They're all 30 days, which means after 12 months, I'm going to have 360 days into it versus 5 days that are going to be, not into it. But I prorate everything based on a banker's month. Okay. All right. Payment, how the payment's going to be made. I allow personal check, but not with the move-in fees. The move-in fees, I want cashier's check or something along that. Or wire electronic payment. Payment via electronic apps. In my world, I leave the default, which says we're not going to accept it. Again, I've had some issues with that. You could check the box that says it will be accepted. That's up to you. Some people like to take the easy way. I just find that when I have problems with tenants, it tends to be over electronic transfers. Rent shall be delivered to whatever that is, whose phone number is, that address. You got to fill all this stuff out, right? And then if checked, rent may be paid personally between the hours of this and that on the following days. Remember, if you allow them to do that, then that means that they can bring it into the office. It could be sitting there over the weekend. You won't even know it, things like that. I was going to say something about that. Let me see if I think about that for a minute. Anyway, I have rents. So I usually, my tenants in properties that I own, I have the tenant send the check in advance. So rent's due on the 1st. I have an understanding with the tenant that I won't cash it until the 1st, but it's due on the 1st. So my tenants tend to send the check in the week before. It sits up on the Davenport or whatever you want to call it in anticipation of the tenant, of the 1st of the month, but I never cash their check before the 1st of the month. That would be disrespectful. But I also don't accept advance rents. As I said earlier, if they want to give me a check for one check for the month of December, January, and February, maybe I'll do that. But never 3 checks, because as I said earlier, the first check is going to be subject to NSF law. The other 2 checks will be promissory notes and handled under a different theory of law. So I want to make sure that the problem with collecting an advance rent, we're going to talk about security deposits in a second, but the problem with collecting an advance rent is that if the tenant gets orders again, they're in there they pay for 3 months, they're in there for a month, all of a sudden they're being shipped out to, I don't know, Finland or whatever, to another country, per the Service Members Relief Act, then I'm going to have to refund them the money. So those are some of the problems. Now, I had a tenant come to us. I was representing a judge in Delmar who owned a property, and the tenant came to us, and they had an unlawful detainer filed against them, and they didn't show up in court. So they actually had an unlawful detainer on their credit report. And so I asked the tenant, I said, why would the owner rent to you? And he says, well, I said, well, what happened in the previous rental? And they said, well, the place smelled like cat urine. And so I didn't pay the rent. And so I said, yeah, but you had a UD filed against you. You didn't show up in court either. There was a whole great big fiasco. So they offered to pay a whole year's worth of rent in advance. So we're going to talk about that in a second. Okay. So Anonymous, do you consider sending payment via Zelle okay? It's not a fee for wire transferring. I understand that. I've had a great question. I've had some really bad experiences with Zelle. Again, not to pick on anybody, but we had we paid one of our agents using Zelle. We paid our agent out of the account, before we were doing wiring and stuff. And so we went by Zelle, and they asked the agent for their phone number. They input their phone number to receive the money. And then the next thing you know, we started getting all kinds of money showing up in our account, not like $1.5 million. I mean, we were getting like $300, $600, $1,200. And so actually none of them more than that. And then what ended up happening was, I just didn't understand where that money was coming from. And so I contacted the bank, and the bank said, well, if we don't know where the money's coming from. No, I don't know where the money's coming from. And so, well, neither do we. We just see the money showing up. And if it turns out that any one of those people happens to also bank with us, which is a national bank, happens to also bank with us, we're going to seize your account for 90 days. Now, we have a lot of money goes in and out of our account. And so for our bank to seize our money for 90 days, I mean, that'll put us out of business pretty quick, right? So we finally got to the bottom of it. It turns out that the person who had entered in their phone number, one of our brokers that we had paid, the bank screwed up and made that the account. So every time his tenants in other states, in Georgia and Florida, were paying their rent, they were now putting it in our account because he had to substitute that phone number for ours. And so that was not a good thing. We got to the bottom of it, fortunately, and reversed all those charges and did all that. But again, our bank to tell us that they would seize our account, that's not going to work well for us as a business. And so that's why I don't use Zelle. I don't trust it. And we've had other problems with it as well. But that's kind of a long answer to a short question. So, oh, hi, Carla. Thank you. I know, folks, listen, I don't want anything to happen to you. I mean, it's important to me that you are okay. And so, those electronic payment methods, I get it. The tenants, we had a tenant on a property. We rented a property to a tenant that we owned, and they wanted to use, was it Zelle or Venmo? I think it was Zelle. And they wanted to use Zelle. And so, the rent comes due. Now the rent, it was $3,500 a month. And so, so on the first of the month, of course, I'm sitting there waiting for it to show up in the account, and $100 shows up. And so I reached out to them and I said, excuse me, to the tenant who's living in the property now. And I said, what's this $100? The rent is $3,500. And they said, well, we don't know. And so they did all their stuff about that. Well, Zelle, this was the first time they had paid us. So Zelle put a limit on how much money they could pay. So we literally sat there and got $100 a day for like a couple of weeks. And it's like, this is just not going to work, and so that was another problem that we had. We've had all kinds of issues. Maybe it's just us. Maybe, I'll take responsibility that maybe I don't understand it, but listen, I'm in business to, it's a for-profit business, and I have enough trouble with that. But it just doesn't work for us with the electronic money platform. So, we have people send us checks, and then, on the first of the month, got a little, take our little picture with our phone and deposit the check into the account. Everybody's happy. I know I've got the check because it's sitting on my dresser for 4 days. And so hopefully I'm not beating this to death, folks, but I'm going to tell you from personal experience, and maybe you have a different experience. I get it. But whenever things go wrong, that's when my phone starts to ring. And so, and listen, I like handling people's, problems, their situations, but sometimes they're just not necessary. So that's just my thing. And so again, down here, if any payment is returned for NSF or because it's NSF, housing provider may provide in writing cash for 3 months, and all future rent shall be payable by either money order or cashier's check. So that's where it's going to go if I get a rubber check. Okay. All right. Rent received shall be applied to the earliest amount due. That means if they didn't pay rent for 2 months, I don't know what they're doing still in the place, but they didn't pay the rent for 2 months, then any money they sent goes towards the furthest back month, and they still have to catch up. Okay. Security deposit. Let's talk about that because this is a big deal. So how much can you charge for your security deposit? Well, first of all, if again, this is a lease agreement, so tenant agrees to pay a certain amount of money as a security deposit. Are you going to transfer it to the owner, or are you you going to hold it in your again, your property manager, so you're going to hold it in the broker's trust account. I would recommend that you hold it only because you've got things to pay for and you don't want to have to keep invoicing the owner, and sometimes you're going to have other issues that are going to happen. So everybody needs to be very clear that it shall not be used by the tenant in lieu of the payment of last month's rent. Now, so you never, ever, ever use the words first and last. So folks, stay with me on this. Repeat after me. Never use the words first and last. You can collect the rents, you can collect a security deposit. So let's talk about those two things. So you can collect the first month's rent, you can collect 6 months rent, whatever, but you're going to call it rent and you're going to call it security deposit. You're not going to call it first and last. Okay. All right. And I'm going to show you why. You agree that if we use your security deposit to fix things on the property that you broke, that you agree to replenish it within 5 days. Otherwise, we're serving you. Okay. Again, I have this conversation with people, and I know folks, I may sound a little hardcore. My tenants love me because why? Because I'm clear with them up front. I never have to evict people. I mean, I can't even remember the last one. My very first rental in Tucson, Arizona, first they brought cash for everything. They'd always show up late, and so finally I just started the eviction process, and so that I show up in court. Right now I travel, folks, and so I had to travel back to Tucson and stand in front of a judge, and the tenant shows up with a newborn, and I'm sitting there going, oh, I am cooked. They're going to own the property. It's my very first rental. They're going to own the property. And so the judge says, why didn't you pay the rent? And the tenant says, I was having a baby that day. And the judge says, you could have had somebody else pay the rent for you. Bang. And I went, whoa, that was pretty impressive. Okay. So, I get it that they had a newborn, but this was a consistent problem for these people. And so anyway, poof, off they go. So housing provider is going to give a list of blah, 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 blah. If the tenant vacates the property, once the tenant vacates the property, you have an obligation at law to return the tenant's deposit or an accounting thereof. That's what the law says. So you got 21 days. So the tenant that's sitting there dangling the keys and says, I'll give you the keys as soon as you give me back my deposit, that's inconsistent with the agreement. Is everybody okay with that? So there's no, you got 21 days. Hit the 21 days. Now I've had people miss it and do 24 and 27. Those are things that I think are just rude. You really need to get it back their deposit within 21 days or a list of what you took out of that deposit. Okay. All right. We're going to see that there's also, the tenant also has a right to try to fix things prior to vacating the property. And that's going to be that 14-day pre-move out inspection. Again, as a property manager, you will issue that form, but because the law requires it. But as just a leasing agent, you wouldn't do that because you don't do property management. Okay. So we're talking about property management here. So let's talk about that security deposit. It's one of my favorite things. I get so many calls on this. Will not be returned until all the tenants have vacated the premises and all the keys have been returned. So I've got 5 tenants. I've had this happen a lot. 5 tenants come into the property. They want to give me 5 different checks. The answer is absolutely not. I want one check. You all decide who the ringleader is, and I want one check from that one person for everything. The deposit, the rents, whatever. And when time comes for us to part our ways and you're going to leave the property, I'm going to issue one check. And it's going to be to that same person that gave me the check. Is that okay, everybody? Does that make it easy? And I tell them that. Now, if you all get together and you all say, here's how we want to disperse the funds, and you all agree, including the one person, then okay, I'll do that. But you've all got to agree to it. Okay. If not, then I'm just going to give that one person the one check. Okay. All right. So, and all keys returned. Okay. All keys, including mailbox keys. And by the way, watch out for those homeowners association common area keys, right? They can be very expensive. Medico keys. I don't know a Medico key that's under $250. Any security deposit return shall be made out to all tenants named on the agreement or is subsequently modified. And again, I issue one check. Okay, so let's see, not to hold broker responsible. If the security deposit is held and broker is terminated for it, and security deposit is released. Okay, so this came up recently. If a security deposit is held by the owner, tenant agrees not to hold the broker responsible for its return. Okay, so the RPO holds it. You're not going to hold the broker responsible. Cool. Okay. If the deposit is held in the owner's broker's trust account, mine, and the broker's authority is terminated before expiration of this agreement, and the security deposit is released to someone other than the tenant, which I've had that happen. The owner comes in and says, I want that money, give me all the money, I'm taking it over, you're off to the hills. Then the broker shall notify the tenant in writing where and to whom the security deposit has been released. Okay. Once the tenant's been provided such notice, tenant agrees not to hold the broker responsible for the security deposit, and that'll save you every single day. You got to read the agreement. Then we have our move-in costs, and again, I always require it to be cashier's checks. I don't really like money orders. I don't like wires, that kind of thing. I don't know. I like doing things the old way. Remember, they used to work, folks. Take a look down here at the bottom of 5. The maximum amount of security deposit. I want to address service animals in this as well. I know that's a surprise, right? So the maximum amount of security deposit, however designated, cannot exceed 2 months rent for an unfurnished premises or 3 months rent for furnished premises, in addition to any rent for the first month paid on or before initial occupancy. This limitation does not prohibit the payment of advance rent. Why? Because we've limited it 2 months for unfurnished, 3 months for furnished. Your current governor has changed that law. That law will change on January 1, that says that the most amount of money that you can collect for a deposit is 1 month's rent, regardless of the type of property. Okay, that's your current governor doing that. Okay, all right. So you cannot charge, if you try to charge them 3 months advance rents, they're going to say you're really trying to get around the security deposit law. So, but you can charge 6 months or greater. Okay, if the term is a 6 month or longer lease. Okay, so just be aware of that. All right. Service animals. Let's talk about service animals. You may not charge a security deposit for a service animal. And so let's do a bundle up here: moving costs received and due. So and I know I've taken longer than I should have, but I never count a pet deposit in the lease agreement. I always make it part of the security deposit. So if I've got $1,000 for the security deposit and they have a pet, then maybe I'll make the security deposit $1,500, but I won't call it a pet deposit. Why? Because if I call it a pet deposit, then I'm limiting myself to the amount I can collect for damages based on the pet's actions. Okay, so to $500. But if I call it just one great big security deposit, I can go after the whole thing. Okay, does that make sense? So I don't call it a pet deposit. Now, on the issue of service animals, you may not by law charge pet deposit for a service animal. Why? Because they're not a pet. They're an extension of the person, what it would be, an extension of their body. Okay, that kind of thing. So you may not charge a deposit for a service animal, period. Okay, all right. So good, we covered that. I want to make sure we did that. Late charges, return checks. Again, my agreement says 0 days because we don't have a grace period in California, and I tell them up front, I'm not going to give you a grace period. If you don't have that rent in by the first of the month, by the date that it's due, I'm going to serve you on day number 2. Now, remember that if they pay the rent within the 3-day pay or rent period, then the full rent, all of it. Don't accept partial, but you have to accept the full rent. And then if they don't give you the late fee, whatever that is, you have to sue them separately for the late fee. Okay, but that's within the 3-day period. If they don't give you all of it, then you can continue the process. If they give you some of it and you accept it, this is why I don't like your rents showing up at your house, and then an 18-year-old takes the rent check at the half of the rent check at the front door. Now you've got a problem. You got to start the process over again. Is everybody good with that? Okay. Again, I will help you. Any questions you have after this, I will still help you. I'm just going to be limited here in time here coming up. So parking, is it included or not? Is there a separate charge? Same thing with storage. Utilities, I usually put in, tenant pays for everything. Okay. Sometimes if there's an HOA, I'll put accept HOA. Water sub-meters, all these things are statutorily required now. So gas meter, electric meter. So if you're renting a property in Del Mar Bluffs, for example, they don't have separate electric meters. They just get one great big electric bill, and then everybody pays their portion of electric bill. So you would check the box that says that it does not have a separate electrical meter. Condition of the premises, I want the tenant to let me know within 3 days whether, whether the property is not in, whether it has anything wrong with it. So we're going to have that move-in inspection form completed by the tenant. Normally, I had a property manager actually complete it recently, which is another way to do it. And then the tenant has to tell you what's not consistent with that agreement. But I want 3 days. Why? Well, because I don't want 6 months. So you do 6 months, and then of course, then you don't know if it was actual damage done by the tenant or whether it was pre-existing conditions. So I want that done right away. Maintenance, use, and reporting. If something's wrong with the property, I want you to let us know right away. Who's going to pay for the gardening? Who's going to pay for the watering? I believe in paying. I pay for the water bill on my properties because I don't want the tenant not watering the property. They disable the rain birds, stuff like that. I'm trying not to be too much of a cynic here, but I don't know. I just had some of the craziest things. Linda's going to have me write a book on what can possibly go wrong. It does. So what else in here? Neighborhood conditions. Drive by the place at, when do you sleep? Between 9 p.m. and 5 a.m. Okay, go there at midnight and make sure there's nothing that's going to set you off. Okay. Animals, again, we're going to have that separate. The new form used to be the petted end on the PET form. Now it's an ATCA form. I love that form. I think it's much better than it was before. Smoking, no smoking is allowed on the premises, period, unless you allow it by checking the box and putting that in there. Rules and regulations. Now, rules and regulations, the owner may have rules and regulations, so they need to provide those to the tenant in a timely manner, 10 days, whatever. But then there may be a condominium that has, bylaws and things like that if we don't tell the tenant what they are, then it's going to be hard for us to nail them for it, right? So I hate to use that word, nail them. So for example, I had a property I owned at 519 Stratford Court in Del Mar. It was a first floor unit in there. I rented it to two gals from UCSD. And I told them, I said, I don't want to get that call that says, you're jumping off the second floor into the pool. Sure enough, I get a letter from the HOA. People are jumping off the second floor into the pool, and they were, in my unit. Well, it turns out they were so excited to get the place, they had a party, and of course, the boys showed up and they jumped off the second floor into the pool. So they didn't realize that I had this conversation with the girls, and so anyway, I went to the girls and I said, hey, your dad co-signed, a big attorney out of LA. Your dad co-signed. I got to let all of the people on the lease know about this. And they said, we'll pay the $100. Don't tell our dad. And there were such great tenants. And I tell you, you talk about having a good relationship with tenants. They stayed with me for years, not only there, but they moved into another property that I had in Carmel Valley. So good tenants. They were really good. You'll give them a copy of all that stuff. Locks. I always check the box, have not been rekeyed. If they have been, then say they have been, okay. But let's see, entry, reasonable notice is usually 24 hours. My lease addendum says reasonable notice shall be 4 hours notice. And then a lot of this other stuff you can read. There is no assignment subletting, no short-term rentals without prior permission of the owner. And then joint and severally obligated. So each tenant is obligated for the entire rent. And once again, that's why I don't collect separate rents. If I collect separate rents from people, then of course, Bob doesn't have the rent this month, and the rest of them are saying, no, we're fine. We paid our rent. We're staying. You're gonna have to go after Bob. And it's like, I ain't doing that. So, Carla, I think you would appreciate what I'm saying. It's just like, listen, I've heard, have we heard it all at this point, right? You've been in the business a long time, possession of the property. Again, you don't have to give them the property for 5 days. I mean, that's crazy, right? Lease starts on the 1st. The owner doesn't have to give them the property for 5 days. I've never done that. I've always given them that day. Tenant's obligation upon vacating. My lease agreement says that they will have the property professionally cleaned, including windows, which, by the way, I gave it to them professionally cleaned, including windows. So I mentioned earlier the right to pre-move out inspection and repair. So there's a form for this. It's called the NTT form. That's not the actual form. Where is it? Anyway, there's a pre-move out inspection form that I have to give them, notifying them of their right to meet with me within 14 days of expiration of the lease to go over what things I'm going to ding their deposit for and give them an opportunity to repair them. And so I think that's fair. What else in here? Temporary relocation, damage damage to the premises. Insurance, we want them to have insurance. We require it. Do they have to have insurance to cover the value of the home? I don't know about that. Just how much damage could they possibly do, right? I mean, burn the house down. Hopefully the owner has insurance to cover some of that stuff. You must fill in the notices part of things. It's usually for the tenants going to be where they are, but the housing provider, wherever you are. Let's see what else. Representations, they agreed not to have lied about anything. Mediation, we've talked about that it's always the default. Attorney's fees. Now we've limited this. This is fascinating. We've limited, and I'm going to wrap this up here in a second. So the prevailing party shall be entitled to reasonable attorney's fees and costs not to exceed $1,000. Okay. All right. So notice over here on the right, we're a third of the way through the form. So here's all the rest of it. Here's my Megan's Law disclosure. I just had a talk with the property manager. You don't need the separate form. You can give it to them if you want to, but you don't have to have it. There's my Service Members Relief Act, et cetera, et cetera. Then I get down here. I go through all this. We've talked about all this already. Brokers sign off on it. Bed bug disclosure required by law. It's a statutory requirement. Tenant flood hazard. I said earlier, C.A.R. template has the box checked that says it is in the zone. Okay. And so, because they can't sue me if it's not, right? Rent cap, just cause addendum. Make sure you check this box right here, assuming that it applies. So I actually don't, I don't know. I have to look at these three. Is my owner one of these three? Right. And so make sure you have that rent cap just cause. Otherwise, you're going to have a real problem with the tenant. There's my fair housing discrimination advisory. So let's fly down here. Here's my information on dampness and mold. And this was included now by C.A.R. By the way, speaking of, I'm on professional standards for the California Association of Realtors. And we are going to, I've been telling you this for decades, to actually since 2006, to add the RA form, the Realtor Acknowledgement Form, to all of your transactions. And they are going to make it part of the template from starting the first of the year. So I've been advocating for this for a very long time. We need to tell everybody the power that we have as realtors, not just licensees. Okay, so here's the dampness and mold stuff. Let me scroll down a little bit here. And then I think finally my CC. Oh, no, that's it. Okay, so that's everything for that. Let's go back to, do I want to save any changes? No. And then really quick, I just want to show you, I know I'm 2 minutes over, but let me show you, whoops, what did I do? I went to the wrong place. Let's go back to my PowerPoint really fast. So addenda, these are all the things that we've talked about already today. Thank you for joining us. Now, YouTube website, get your QR code reader ready. This will take you to the website where we have all of these webinars. But the other purpose behind it is that the DRE is required that I have to put the general information page from the DRE approved courses that I teach, so that everybody can read them before they sign up for the class. So this is why we're doing these kinds of things. So you can type into your browser at Burke Real Estate Consultants Inc. We're not just a real estate company. We do I do a lot of trial. Probably half of my work is trial work. So there's a bit.ly link. Case is important. So bit.ly/real-estate-ed. Please remember to like and subscribe. And why? It makes me feel good, but subscribe so that you get the updates. So it tells you when I have a lot of subscribers, and when I start doing my podcast, it's going to go crazy. So you need to subscribe so you know that when they're coming. On the 29th of November, now I did a podcast for the Department of Real Estate a week or so ago. They're going to go live with it on the 29th of November. So you won't have a chance to interact with me, but you'll hear my take on first-time home buyers and what we're experiencing right now. Again, the #1 most complained entity at the Department of Real Estate. And so here's the website. You just go to the DRE website. Consumers is a link up at the top, and then you just click on First Home California to get to that. I think let me see here. I'm going to go over here. Let me go to the DRE. Where's my home page? There we go. Home. See consumers right here. See First Home California right here. When you click on that, you get First Home California. There it is. So you'll see me live. Well, you'll see me on the presentation on the 29th. And then majority of complaints filed with the DRE from first-time home buyers. Boy, that makes me really sad. buyer representation agreement. So I'm going to start breaking that down by paragraphs. So if you know what paragraph number 2 says, but you only want to know what does paragraph 4 say, then you'll be able to look by paragraphs, and those are going to be in the podcasts. So that's what we're going to be doing. And again, that's separate from SDAR. I've been talking to them about doing that, but 2 hours sometimes is a lot of time, and I can't get half of it done sometimes. Send them an email. Say, hey, we need Kevin to do podcasts, something shorter that, half an hour, 25 minutes, something we'll listen to in the car. We can call in and ask questions, stuff like that. Education SDR, copy me or send it to me, copy them, whatever you prefer. My weekly email updates. If you're getting my newsletter, then you know what we're doing. Okay. If you're not getting the newsletter, you should probably sign up for the newsletter because that's where we're going to tell everybody, what is happening next. Okay. So I hope I'm here to help. I'm not here to sell you anything. I really truly believe that I'm paying back. 44 years ago, 1979, I got my real estate license. People helped me when I first got started in real estate, and I feel like I should be helping people today. I had people helping me. I've only been in the real estate for 5 years. I'm helping you. I've got 44 years. I got other things to do. I want you to do well. Okay. And so, as I always say, if you look good, you make me look good. I want you to look good, folks. Thank you, Carla. Thank you so much. That's very kind of you. But if you look good, you make me look good. I want you to look good. I'm not even going to take credit for it. Okay. So thank you all for being here today. Hopefully I get to see you this afternoon. Excuse me, I'm going to show you some amazing shortcuts on how to create templates in zip forms. So as we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Take care for now. Bye-bye.